everyone!
Hello, welcome to MyData-NEWS.
Yes, we have some great news of this month, and you can already see the agenda on your screen. And for example, I think we have some good news about UK and the IDTA agreement.
Yeah, very good hot topics.
Yes, also we have some news about Google Analytics.
And also like the guide from the CNIL for the DPO. It's very interesting.
Yes, there's
and helpful.
Yes, a lot of interesting news. So let's start.
Yeah, let's go with the life sciences news. So the European Commission is set to propose a new governance framework for health data with cross-border interoperability requirements and a pan-European infrastructure in the first sectorial legislation of this kind. And the main goals of the regulation are to make the healthcare sector more efficient and advance scientific research in the telehealth area, and unleash the health data economy, fostering the development of new digital health services and products.
Okay, great. And the ABPI consults on health data use principles. So, the Association of the British Pharmaceutical Industry has opened a consultation on draft principles for the use of health data. And this IBPA says that there is enormous potential in the data collected and stored by the NHS to improve research and medicines. So ABPI explains that the access to data was invaluable for the effectiveness of the NHS response to COVID-19 and from vaccines to treatments. And there is 5 principles consulted on these ABPI consultations that are, for example, transparency of purpose, the clarity of arrangements, patient and public involvement and engagement, non-exclusivity of arrangements, and last one, compliance with law and regulations.
After that, the Spanish Data Protection Authority approved on the 25th of February the Regulatory Code of Conduct for processing of personal data in the field of clinical trials and other clinical research and pharmacovigilance. In particular, the Spanish Data Protection Authority noted that the Code of Conduct was promoted by Pharma Industria, which is the National Business Association of Pharmaceutical Industry. Moreover, the Spanish authority highlighted that the Code of Conduct regulates how the sponsor of clinical studies of medicines and the contact research organizations that decide to adhere to it must apply the General Data Protection Regulation, the GDPR. In addition, the Spanish Data Protection Authority provides that the objective scope of application of this Code of Conduct is the activities of treatment of personal data in the framework of clinical investigation in general, but also clinical trials in particular, as well as those related to compliance with the obligation imposed by current regulations on pharmacovigilance for the detection and prevention on adverse effects of medicinal products already marketed. I continue with the last news regarding the life sciences. So Clearview AI fined like 60,000 in Italy for failure to appoint GDPR representative per Article 27 of the GDPR. Over the last couple of years, Clearview AI has been investigated and sanctioned by a number of EU data protection authorities for their uncompliant data processing activities. Italy's contribution appears to be the most significant yet, and for the first time includes sanction for Clearview's ongoing failure to appoint a representative in the EU as required by the GDPR.
Yes, thank you. So now let's change the subject with some data protection news. So, US-EU Privacy Shield talks inching closer to a deal. So, US and EU negotiators are close to finalizing a transatlantic data transfer mechanism, an agreement to simplify the exchange of personal data between the two regions that could be announced as early as this spring. And speaking last week at the State of the Net conference in Washington, US Department of Commerce Privacy Shield Director said that his team and their European counterparts are trying to clear up the fuzziness around international organization information exchange as quickly as possible.
Yeah, just to complete like Manon information, a new data transfer agreement with the US is a high priority for the EU, agreeing a new data transfer agreement with the US is really like the most important subject for the moment. But Margaret Vestager, the EU Commissioner, warned that a replacement for the defunct EU-US Privacy Shield and Safe Harbor before that is by no means a done deal, given the fundamental legal clash between European privacy rights and US surveillance overreach.
And still in the United States, President State of the Union address highlights need for strengthened privacy protections. So at the beginning of the month, Joe Biden addressed the US Capitol in the 2020 State of the Union. Among other things, the president highlighted the importance and intention of strengthened privacy protections and the need to ban targeted advertising to children, as well as hold tech companies accountable for their practices and limit or maybe stop the collection of personal data of children.
I continue with TikTok. TikTok shares your data more than any other social media app, and it's unclear where it goes. So the study found that YouTube, which is owned by Google, mostly collects your personal data for its own purposes, like tracking your online search history or even your localization, to serve your relevant ads. But TikTok, which is owned by Chinese tech giant like ByteDance, mostly allows third-party trackers to collect your data, and from there, it's hard to say what happened with it. So as the study noted, third-party tracker can track your activity on other sites even after you leave the app.
ICO publishes third chapter of anonymization and pseudonymization guidance for consultation. So ICO has released the third chapter of its extended consultation into draft guidance on anonymization, pseudonymization, and privacy-enhancing technologies. And the first chapter of the draft guidance introduces anonymization. The second chapter talks about effectiveness of anonymization, and the third one of the draft guidance focuses on pseudonymization and explains the key difference compared to anonymization.
I will continue with two guidance from the EDPB. The EDPB has published guidelines on example regarding personal data breach notification. The guideline set out a number of example scenarios where it will be necessary for data controller to provide a notification to a supervisory authority under the Article 33 of the GDPR, and where relevant to data subject under the Article 34. The examples in the guidelines are from practice and are under common categories of breaches, with associated mitigation and preventive steps for each scenario along with notification obligation. After that, I will continue with the adopted updates to its guideline for using code of conduct as a tool for data transfer. The guideline, originally adopted in July 2021, aimed to provide clarification as to the role of the different actors involved for the setting of a code to be used as a tool for transfer and the adoption process with flowcharts.
Thank you. There is a second wave of complaints underway about cookie banners. So advocacy group NOIB sent 270 complaints to a range of website operators in its latest round of filing regarding alleged cookie banner violations. And Max Schrems-led group previously filed hundreds of similar complaints in May 2021 and claims many of those resulted in changes to cookie display practices. And Schrems said, "We want to ensure compliance, ideally without filing cases, and if a company, however, continues to violate the law, we are ready to enforce users' rights."
Thank you, it's very interesting. I continue with the Civil Liberties, Justice and Home Affairs Committee of the European Parliament, which announced that it will hold a public hearing on the implementation and enforcement of the GDPR on the 17th March 2022, following the European Parliament resolution calling for an improvement in this area 1 year before. In particular, the LIBE committee highlighted that the hearing will aim at taking stock of the implementation and enforcement of the GDPR, the challenges faced by different stakeholders in this regard, and possible way of improvement.
So there is some great news in the UK. The International Data Transfer Agreement that we call IDTA came into force this week. So as a reminder, organizations can now use the IDTA or the addendum as a transfer tool to comply with Article 46 of the UK GDPR when making restricted transfers. So the IDTA and addendum replace the current standard contractual clauses for international transfers, and they take into account the binding judgment of the European Court of Justice in the case commonly referred as Schrems II decision. So these documents are immediately of use to organizations transferring personal data outside of the UK.
I come back to my previous information regarding the Civil Liberty, Justice and Home Affairs Committee of the European Parliament, who held also a public hearing on the implementation and enforcement of the GDPR and issued a follow-up statement later that day, on the 17th of March. In particular, members of the European Parliament, representatives from various EU and member state authorities, including the European Data Protection Board, the famous EDPB, but also the European Consumer Organization and some data protection authorities, as well as business leaders in the data protection domain, discussed current issues in 3 thematic panels, namely regarding data subject rights, enforcement and collaboration, and significant cross-border cases.
There is some news about EDPS because they consider that EU needs more restriction on targeted advertising. So European Data Protection Supervisor, EDPS, wrote a blog post urging increased scrutiny and regulation of the advertising technology space, and he recommended efforts to rein in targeted advertising through transparency and accountability principles in the proposed Digital Services Act. But noted transparency is essential, but it's not enough. So he added the EU needs regulatory incentives to favor less intrusive forms of advertising that do not require tracking, while proposing further restricting the categories of personal data that can be processed for targeted advertising purposes.
I continue with a new guideline regarding the EDPB. So the guidelines adopted by the EDPB on dark pattern in social media platform interfaces. The guideline offers practical recommendations to designers and users of social media platforms on how to assess and avoid the so-called dark patterns in social media interfaces that infringe on GDPR requirements. Dark patterns are interfaces and user experiences implemented on social media, the processing of their personal data. This influencer user behavior and ability to effectively protect their personal data. The guidelines give concrete examples of dark pattern types, present best practices for different use cases, and contain specific recommendations for designer of user interface that facilitate the effective implementation of the GDPR. And those guidelines are open for consultation until the beginning of May. I continue with also the EDPB that has also published its toolbox on essential data protection safeguard for enforcement cooperation between EEA data protection authorities and competent data protection authorities of third country, under the Article 70 and 50 of the GDPR. In the context of the Article 50 of the GDPR concerning international cooperation with third countries, competent data protection authorities, the following toolbox of essential data protection safeguards to be concluded in addition to or insert in an enforcement cooperation agreement has been developed.
And there is a great update with Google Analytics. So we are talking about Google Analytics 4.0. So no more IP address logging or storing, maybe. So there is major change that are coming to Google Analytics. And for one, Universal Analytics, the web-based legacy analytics project, is on the way out and will be shut down entirely by July 2023. that's the thing that Google announced last week, actually. And all analytics customers will transition to Google Analytics 4, which accommodates both web and app data collection and comes with built-in privacy features and integration across the Google portfolio with metrics and features tied to YouTube, search, and Google Cloud platform. And the most consequential change is that Google Analytics will no longer log or store IP address information. And Google Analytics is under fire in EU countries because Schrems 2 ruling prohibits Europeans' data from being shared to US servers. And Google may hope that localizing IP address visibility and preventing the data from leaving a country will relieve the pressure on Google Analytics in the EU, but many EU nation regulators have outright banned its use.
Thank you. So you can also find the new guidance in English from the French Data Protection Authority, the CNIL. This new guidance highlights important aspects to take into consideration when appointing an internal or external DPO, the Data Protection Officer. Most of this advice is relevant to the appointment of a DPO in any country in the European Economic Area. The GDPR does not set a requirement for the DPO's location. However, in EU cross-border processing situations, the DPO must be designed with the lead authority. Overall, the DPO must be easily reachable by data subjects and the Data Protection Authority. The CNIL therefore recommends that the DPO be located in the European Union, whether or not the data controller or data processor is established in the European Union. If the organization doesn't have an establishment in the European Union, DPOs may be established outside the EU, provided that they can effectively perform their duties. The guidance also refers to DPO independence and resources.
Amazon workers demand data transparency. So in cooperation with the trade union UniGlobal and the privacy node company, Amazon warehouse workers from Germany, the UK, Italy, Poland, and Slovakia filed access requests under Article 15 of the GDPR. And the goal is to find out how Amazon unless workers' personal data under the EU's GDPR, and workers have so far been left in the dark about how their data is used, despite the fact that Amazon uses sophisticated systems to monitor workflows and workers. And Amazon has 1 month to respond and fully disclose its handling of workers' personal data. I have another news about Tinder, because now Tinder offers criminal background checks, but there is a more big problem. As of last week, actually, Tinder user will be able to run a criminal background checks on their potential dates, and the feature, launched in partnership with Garbo, a background check provider that aims to make public safety information more accessible, is intended to make Tinder users feel safer. But experts who specialize in sexual violence and surveillance have said the move is misguided and risks amplifying the bias inherent in the criminal justice system.
Thank you, Manon. We will continue with the last part of the MyData-NEWS regarding the legislation. So, the revised Swiss Data Protection Act is to be set in force only on September 1st, 2023. So the recent rumors have been confirmed. The revised Swiss Data Protection Act is to be set in force only in September 2023. The date has yet to be confirmed by a decision of the Federal Council, but it has now been published on the Federal Administration website. So far, the general expected date was January 2023, and officially still the second half of 2022. One reason for the delay is likely the heavily criticized first draft of the revised ordinance of the DPA, which is currently undergoing a general overhaul.
Will the Utah or Florida become the fourth US state to pass a comprehensive consumer privacy law? So the Utah House passed the Utah Consumer Privacy Act about last March 2, and end of February, the Utah Senate already unanimously passed the bill, actually. And however, because of a House amendment, the bill will not move back to the Senate for concurrence. Those looking for groundbreaking privacy law will not find it with the Utah bill, because the bill is a significantly watered-down version of the VCDPA, so the Virginia Privacy Law. Meanwhile, the Florida House passed HB 9 last week, actually, also. But there is other US changes, because the Wisconsin Assembly passed a bill last week, but time is tight, where there are two with the legislature scheduled to adjourn, also last week. And note that the Wisconsin bill is a VCDPA clone also. Also, the Connecticut senator introduced the full version of his bill also last week. There is a new bill announced introduced in Kentucky, and Virginia lawmakers passed a VCDPA amendment too.
A lot of news in the US.
Yes.
We continue with Uruguay. So the Uruguayan Data Protection Authority published recently a guide on personal data protection in Uruguay. In particular, this Data Protection Authority states that the guide is intended both for citizen and public and private organizations that are responsible for guaranteeing the right to privacy and data protection, and that it details the operations and powers of the Uruguayan Data Protection Authority, as well as the principle and rights. As such, the guide highlights the principle of data protection such as legality, accuracy, purpose, and data security, discusses the rights of data subject, such as the right to access, the right to be informed, the rectification, the suppression, inclusion, and deletion, among others, and discusses the processing of sensitive personal data.
At an international level, global coalition raises concerns over India's personal data protection bill. So the Information Technology Industry Council, called ITA, announced on March 2022 first that it had led a coalition of global tech and business associations to issue a letter to the government of India in relation to concerns over the personal data protection bill of 2018. In particular, the ITI noted that it cautions against the bill's potential negative impact on India's innovation ecosystem and the digital economy. And in this regard, ITI has requested the Ministry of Electronics and Information Technology to launch additional stakeholder consultation before introducing the bill in Parliament. And now in Saudi Arabia, there is issued draft executive regulation of personal data protection law for public consultation. And the Saudi Authority for Data and Artificial Intelligence issued last March 10, 2022, in collaboration with the National Data Management Office, the draft executive regulation for the data protection law, then launched a public consultation on the same. And in particular, the draft executive regulation aimed to clarify procedures and implementation of the provisions of the personal data protection law.
In Vietnam, the Ministry of Public Security shall assume the prime responsibility for and coordinate with the Ministry of Justice in researching and proposing the development of a law on protection of personal data.
And there was a recent CPRA update. So since the passing of the CPRA, businesses have had some time to consider its provision and think about what they need to be doing to prepare for its operative date. But most recently, the CPPA board initiated a public consultation on September 2021 on proposed rulemaking under the CPRA, and which ended beginning of November 2021. And the results of the public consultation were released mid of December 2021. And the topics discussed in the consultation included, for example, processing posing significant risk to consumer, automated decision-making, audits by the CCPA board, matters around consumer rights, information to be provided in response to a consumer request to know, and last example, matters around definition and categories of information and activities.
Thank you, Manon. It
you,
was the
Victoria.
last news of
Yes.
this month.
I hope you enjoyed the news of the month and that you will be there next month for more news.
And do not hesitate to follow us on the different channels. We are also on LinkedIn and on Twitch. And if you want more stronger and complete information, do not hesitate to subscribe to our newsletter for our articles. Thank you.
Thank you. Bye-bye.
Bye.